People against Grasso.
Ready for court, please?
Ms. Underwood?
I'd like to reserve 5 minutes for rebuttal.
Certainly.
This case concerns the Attorney General's traditional parents' patriae power to protect the assets of organizations that serve a substantial public function and have no traditional owners entitled to dividends. That power existed in early modern England, and it exists in America today, and there is no evidence that when New York enacted a not-for-profit corporation law in 1969, it intended to displace that power.
And there are 4 causes of action.
That's correct.
You're seeking to sustain here.
That's correct.
And these are the so-called hybrid claims or the common law claims. They're not statutory.
Well, 2 of them are common law claims, and 2 of them are the assertion of the Attorney General's common law power to enforce a statutory obligation. The first and fourth counts are the common law claims for unjust enrichment and money hadn't received. Common law, I should say, plays 2 roles in this analysis. There are the common law causes of action, and there's the Attorney General's common law power to enforce.
Can I ask you something, Ms. Underwood? The ones that are still remaining, cause of action number 2 and cause of action number 3, what relief, if you were ultimately successful, do you seek? Or would you be able to?
The relief from those statutory causes of action that we seek is the same as the relief in the non-statutory causes of action, namely the return of the unjust, the excess of compensation. They are simply different theories by which we seek that relief.
That return of compensation, though, doesn't go to the public treasury. It would go back to the exchange?
Well, it would, in principle, go back to the exchange because the exchange has now changed its corporate form, and because we are asserting these causes of action on behalf of the public regarding function of the exchange. The money we have said would go to the regulatory arm, which is still a nonprofit, of the successor to the exchange. The exchange now has taken the form of a for-profit corporation for some functions and a nonprofit for its regulatory functions. So there's a complication that arises out of the change in the structure of the
What case most clearly establishes the existence of the common law power that you say the Attorney General has?
Well, there are 2 aspects to the common law power. There's the common law cause of action for unjust enrichment, and there's
No, I'm talking about the common law standing that you say the Attorney General has to bring the lawsuit.
Well, I think SNAP is really the
Is there
key.
any New York case that says as a matter of New York law, the Attorney General has this power?
Well, there are numerous old New York cases in which the Attorney General in which the Attorney General's parents' patriae power is referenced. They go back to, and we cite them in our brief, Davis against Mayor of New York, I suppose, Ingersoll, in which the state sought return of funds stolen from the city by corrupt public officials. The state said, this court said in 1874 that the Attorney General may prevent misappropriations and abuse of power and protect those that cannot protect
Is there
themselves.
anything since the enactment of the not-for-profit corporation law?
Well, not from this court. Of course, in the Diamondopoulos case, which was in a trial court, the Attorney General sought the return of excess compensation from the president of Adelphi. That didn't go to a higher court, but it sought it as a matter of unjust
I guess
enrichment.
The implicit in my question is why shouldn't we, the not-for-profit corporation law does say at one point the Attorney General can bring these particular causes of action, which are your second and third. Why should we not infer from that that those are the only ones that the legislature intended him to bring?
Well, there are several reasons why the not-for-profit law it's not appropriate to read it as exhaustive, either with respect to causes of action or with respect to the Attorney General's power to bring causes of action. One, we have a principle that when the common law is displaced, it ought to be said explicitly. Two, the statute expressly in 719F acknowledges and preserves other liabilities of directors and officers other than the ones enumerated in the
But
statute.
just staying there, Ms. Underwood, the legislature has, your two causes of action, your second and third, require some element of knowledge or bad faith. Why should we go beyond that to essentially condone the first and fourth causes of action?
Well, a common law cause of action for unjust enrichment is simply different from an action for fiduciary breach in a number of respects, not just in that respect. And this is true whether it's brought by private individuals, like the corporation, or by the Attorney General. It doesn't require fault on the part of the person enriched, because the injustice may be the result of someone else's fault, as in Simons against Simons, the testator's fault. Or it may be the result of a mistake, which isn't covered by this statute at all. But it does permit equitable defenses, as this court observed alluded to in Sperry against Crompton, when it said that an excessive attenuation between the plaintiff and the defendant was inappropriate for unjust enrichment, or in Paramount Film Distribution, which is cited in Sperry, when film distribution companies sought money back from the state on an unjust enrichment theory, because the fees that they had paid were later determined to be improper, and this court said that's an equitable claim, unjust enrichment, and we decide whether there's been detrimental reliance and whether the money has now been dispersed and what the equities would be.
Ms. Underwood, doesn't your rule, what's left of the business judgment rule if we adopt your theory?
The business judgment rule is a rule for fiduciary breach. In fiduciary breach, there is also consequential damages. That is to say, an action for fiduciary breach is not just an action to get back the money that was improperly paid. It can be an action for damages that can go well beyond that.
Well, doesn't it tend to vitiate the fiduciary, the business judgment rule, though, for directors and officers in not-for-profits, if you can sue outside the regime of that statute under these common law theories? Doesn't it tend to get rid of it?
Actually not, for a couple of reasons. One, as I said, it doesn't involve damages. It just involves a claim. An unjust enrichment claim is just a claim to get the money back. If the directors, as in this case, don't have the money, they are not subject to the unjust enrichment claim. Only the holder of the money is subject to that
From your point of view, this is as though the New York Stock Exchange had overpaid its phone bill?
Grossly overpaid its phone bill to the
Because
point
my question is, granted that the stock exchange would have a cause of action to get the money back, why should the Attorney General have to do that? Why can't the management of the stock exchange handle it?
Well, that raises the special problem of the stock exchange, in which its members had a conflict of interest when it came to policing the management to prevent extravagant expenditures of this sort, probably not with respect to the phone bill. But the members were regulated by the management here, and they, therefore, as a result, had a strong competing interest in not cracking.
Aren't you describing a fiduciary breach?
It depends on what they knew and what, that would be a matter for trial. We have alleged a fiduciary breach, but a fiduciary breach will turn on such things as who knew what and who.
Where there's no fiduciary breach in question, right. I don't really see why you need the intervention of the Attorney General. But here, as I understand it, the present management of the stock exchange is is on your side.
Well, the stock exchange is completely reorganized at this point, but while this was going on, the members of the stock exchange did not, it's a fact that they did not police this problem. The question why or how that came to pass will be an issue at trial and will relate.
But as I understand, your unjust enrichment claim is a claim that you say you can prove without proving any breach of fiduciary duty.
That's correct. Well, without proving any breach of fiduciary duty on the part of the defendant. It's possible that there will be breaches of fiduciary duty elsewhere.
But you don't have to prove that. That's not a necessary element of your claim.
No, we have to prove injustice of some form, unjust enrichment, and the law of unjust enrichment, on which the ALI is just now producing a whole new restatement, provides for a number of different ways of establishing the injustice, which could be fraud, or it could be mistake, or it could be misleading. One of the facts about this contract, one of the reasons I might say why the existence of a contract doesn't defeat the unjust enrichment or money hadn't received claim, is that the contract itself didn't actually spell out the terms of the compensation that we say were excessive. It simply provided, the first two contracts simply provided that the defendant was eligible for various incentive, bonus, and compensation plans.
Underwood.
If I could go back to the legislative, the scope of the legislative authorization, because the not-for-profit law has almost 24 specific authorizations for the Office of the Attorney General. Was that an unnecessary exercise? Because some of your causes of action are practically identical to the statutory causes of action, other than one or two elements.
Well, the fact that there is overlap between common law actions and statutory actions doesn't mean that either one is redundant or was not intended to exist. You can't always bring a common, why would you have a statute? Because the common law claim doesn't always exist. For example, if the assets have disappeared or equitable considerations weigh against recovery, and you can't get full relief, you can't get the consequential damages under a common law claim.
Ms. Underwood, do you depend on our finding this parens patriae power for all 4 causes of action that are in issue here?
Yes, yes.
Without that, they're all stricken.
They are all assertions of the Attorney General's parens patriae power to enforce a legal obligation that comes from elsewhere.
But we have been focusing in the questioning on the first and fourth causes of action, and the same argument is true, you say, with respect to the fifth and sixth?
Yes, although they have there's a slightly different structure for those.
But still, without our finding the parens patriae power in the Attorney General, those were correctly stricken as well.
I would say that's correct. Count 5, however, I'd like to point out, which is an enforcement of the statutory requirement of board approval. Here, the Attorney General is not changing the elements of the cause of action at all, as the appellate division suggested. The Attorney General seeks to enforce the statutory obligation as written. If there's a good faith defense to that, then it exists for the Attorney General's claim as well, because that's not a common law action, cause of action. That's the Attorney General's common law power to enforce a statutory obligation.
Why do you say that the legislature created certain statutory obligations and gave the Attorney General, explicitly gave him power to enforce some but not others?
The fact that the legislature specifically gave the Attorney General powers is not to say that the Attorney General doesn't have powers in those cases where the parent, after all, the category...
Do you have a reason to suggest why the legislature made that distinction?
Yes, the legislature was making law for all nonprofits. The world of nonprofits ranges from purely private clubs organized by, funded by, and serving only their members, like a country club, to organizations that receive money from donors and redistribute it to completely different beneficiaries, like a charity, and to organizations in between, like this one, organizations that provide services both to the people who fund them, the members, and to others, to the public, in the regulatory function and the making of a market that was going on here.
Have you exercised your parents' patriae power in your experience? I realize in response to Judge Smith, you can't think of any particular case site since the not-for-profit corporation law came into existence. But in your knowledge of the Attorney General and in the business of the Attorney General statewide, is the power that you seek to exercise in these 4 causes of action commonly used, and can you give us some examples if it is?
Well, it's commonly used to enforce consumer protection laws. It's commonly used to enforce civil rights laws. SNAP it's a United States Supreme Court case, but it's perfectly typical that a statute which doesn't specify that the Attorney General may bring an action, which simply creates a right, is then enforceable by the Attorney General.
The cases you to the consumer protection and the SNAP are cases where the Attorney General was suing on, or the state was suing on behalf of a fairly diffuse group of small victims. Isn't this different? Aren't you really suing on behalf of one pretty well-heeled victim?
No, we are not suing on behalf of the corporation. We are suing to vindicate the interest of the general public, the investing public.
But the only remedy you seek is money payable to the corporate treasury.
Well, money payable actually to the treasury of the regulatory entity to enhance regulation, to improve the market in which the investors...
What prior case looks most like this one, previous parents patriae case that you would say is most similar to this?
Well, the reason I keep coming back to SNAP is that what SNAP was about was a law that, on its face, simply provided for employment opportunities for Puerto Rican citizens in the United States. And the reason the Supreme Court said that Puerto Rico could bring that case wasn't to assert the right of those people. It was because the economy of Puerto Rico and the purpose of this statute was to provide benefits, to provide employment benefits, and there was a whole interest in Puerto Rico that was separate from the interest of the individuals. And that's what we're asserting here, not the interest of the corporation, although that's the relief that the statute provides, but we want that relief for a different reason than the corporation might want that relief. We want that.
I know your red light is on, but if you're successful with our court, will you be abandoning the 2 statutory causes of action going forward?
We'll go to trial on all of them, although, of course, if we can get all the relief that we want on a non-statutory cause of action, there may be no need to proceed on a statutory cause of action. But all 6 cases, all 6 causes of action will be then remanded for trial unless there's some litigation concerning those.
And there are additional causes of action as well. The 7th and 8th?
Well, the 7th, one of them is against a different person, and one of them is against the stock exchange. So these are the 4 against these are the 6 against the defendant Grasso.
Thank you, Ms. Underwood. Mr. Zwartek?
Please, the court. Let me begin with a different answer to Judge Graffaio's question. The Attorney General has already made clear what it intends to do with these causes of action. It intends to leave the statutory causes of action behind, as well as the choices that the legislature made on who should be liable and why, because what he's done is, when our motion to dismiss was denied, the Attorney General successfully moved to sever the first cause of action for constructive trust and advance it for a bench trial. In other words, the reasonable compensation standard of the statute, which was embodied in a statute in which the legislature said what the standard of liability should be and who the trier of fact should be, would be jettisoned, and we'd have a bench trial on that issue. And that was what the Attorney General asked for.
Are you entitled to a jury trial on the 2nd and 3rd causes of action?
Absolutely. But those are gone, Your Honor, if the Attorney General has his way here. Because what the Attorney General is seeking to do is to walk away from the policy choices that the legislature made when it said there shall be no liability without fault.
Well,
it's not like they didn't think about this. That's what they wrote.
Why isn't this a good case for the Attorney General to assert his parents patriae authority?
Well,
Why doesn't this fit within the criteria for that?
it doesn't fit within the criteria for a number of reasons. The first, of course, being that this is an action brought effectively to seek relief that a private litigant could obtain in its entirety. The statutory causes of action could be brought by the New York Stock Exchange. They could get the same relief, and it would have the virtue of proceeding along the lines that the legislature commanded.
Except they didn't do anything, and there is some public interest here in terms of the integrity of the stock exchange.
But right now, what we have is Mr. Grasso is forced to resign. The stock exchange works up the case, does 50 interviews, does the expert reports, does everything but file the lawsuit, and then hands it off to the Attorney General. And so you have, I would suggest, the least likely ward of the state for a parents' patriarch
But
case.
isn't the claim that the stock exchange was, the will of the stock exchange overcome by Mr. Grasso?
Well, first of all, the will wasn't overcome when he was run out of the
There
place.
is such an allegation.
There is an allegation, but the question is, at the time the suit is brought, is there some reason to recognize parents' patriarch authority because the stock exchange is unable or unwilling to proceed? That's absolutely not the case. The stock exchange worked up the case. But let me complete my answer to Your Honor. The reason that the parents' patriarch authority is not even at issue here is because the appellate division didn't find the need to cut it back or address it at all. And that's because the appellate division decided this case not based on the parents' patriarch authority, but based upon the proposition that no litigant can rely upon a statute for the substance of his claims and then impose liability in a circumstance where the legislature expressly said no liability shall lie.
But we have to agree, don't we, with you that there is no parents patriot? Let's say we agree with you on the grounds on which the appellate division decided this case. In order for you to be victorious, wouldn't we have to reach the parents patriot? We would not?
No, just as the appellate division never needed to reach it.
Because it was never pleaded?
No, all they needed to reach was this. No litigant can rely on a statute for the heart of his claim and then seek to impose liability where the legislature said in the same statute there shall be none. The parents.
You're saying that we could assume, well, even though you don't agree, we could assume that the parents' patriarchal power would exist but for the specific authorization to the Attorney General in Section 720?
Absolutely.
And even on that assumption, you said that because there's a specific authorization, that implies an exclusion of what assumedly would otherwise be a good parents' patriarch claim.
You could do just as the appellate division did. Let's say they had standing under parents patriae. Neither SNAP nor any other parents patriae case ever decided has ever said it not only enhances your standing and allows you to intervene, it allows the Attorney General to come in and rewrite a statutory directive. The legislature was absolutely clear here, and it should be known, the Attorney General has argued to you in their reply that they don't really rely on the statute for these four causes
Well, the
of action.
legislature has said these are the elements of the statutory cause of action, but it hasn't said there shall be no other.
Actually, well, Your Honor is right. They didn't say there's no other possible causes of action, but here's what they said. In Section 717, after elaborating on the duties of directors, they said that a director any person who complies with his duties under the section shall not be liable by reason of having been an officer or director. And specifically, the legislature looked at the question, what do we do when someone's overcompensated?
And that's enough to establish exclusivity?
Well, let me,
As-
the exclusivity comes from here. The legislature established the reasonable compensation limitation that is cited in those so-called common law causes of action. The heart of their claim is a violation of Section 515 of the NPCL. That's the engine of the claim. If you're going to make a claim based upon a violation of that directive, the legislature has said, here's who can be liable, and here's on what grounds. In other words, the Attorney General says this is really an unjust enrichment case, but it's not correct, because the common law would never have provided a vehicle for a no-fault attack on compensation. Simons wouldn't apply here because Simons, as Judge Breitel said, dealt with a plaintiff who had no other recourse and was a gratuitous donee. But this court has said when it comes to compensation, that's not a gratuitous donee. This court has said in Kalmanash versus Smith, the leading case on a corporate waste claim, that decisions about compensation are vested in a board of directors whose judgment shall not be overturned absent wrongdoing amounting to bad faith.
What about the sixth cause of action, which is framed as a loan rather than compensation?
There, too, the legislature said that those who make illegal loans under Section 719 shall be liable if they violate their duty in doing so. In other words, the legislature took up every one of the substantive prohibitions that are found in these so-called common law claims. They are the author of the substantive prohibitions. And yet the legislature said, but there shall be no liability for their violation in the absence of proof of bad faith to be proven to a jury. So here's what we
So
have.
exactly what's left? That's the same question I asked Ms. Underwood. The second and third causes of action, if they were to prevail on those causes of action, what would their recovery be?
They
Or
would
could be?
recover whatever the jury deemed to be unreasonable compensation if they found that Mr. Grasso violated his duty of good faith and reasonable prudence. That's what the legislature.
If they find that, can Ms. Underwood get all the relief she's looking for?
Absolutely. I mean, here, unlike.
So what's the fundamental difference that you see between the common law and the statutory? Does the statutory offer you more defenses? Is that?
The fundamental issue that's going to be decided by this court is this. Who is the trier of fact and what is the standard of liability? The legislature's already spoken to that. The legislature said that where there is a violation of the limit on compensation, here's who's liable, officers and directors. Here's what the standard is, good faith and reasonable prudence. Here's who the trier of fact is, the jury. They insisted upon that. They said it in 717, which is the duty of officers and directors. They said it in 720, where they essentially incorporated it into the substantive causes of action. They even provided that if the directors are sued and they're held liable for having paid Mr. Grasso too much, even though they got none of the money, they can recover from him in subrogation only if they establish that he took the money with knowledge it was illegal. That's 719D1. The legislature was tenacious in insisting upon codifying the business judgment rule. It took it from the common law, it built it into the statute, and what's at issue here is this. Can the Attorney General jettison all of it by insisting on substantive violations of the statute? If you would look at the complaint, it's all about violations of the statute. Those so-called unjust enrichment claims are all premised on violations of the statute.
If we affirm, if we agree with you.
Yes.
Can the stock exchange itself take over the 4 causes of action?
No, because the separation of powers applies not only to the Attorney General and the legislative branch, but it would apply to a litigant seeking to circumvent a legislative command about who shall be liable by
So you say this
enlisting the
in
court.
your view, this isn't just a question of the Attorney General's standing. You're saying these substantive causes of action don't exist?
They don't exist because the legislature, if you would, the causes of action expressly rely on violations of the statute. In other words, what is the constructive trust claim? It's called constructive trust, but that's where the common law aspect of it ends.
So how would board members protect their own interests?
The board members protect their own interests in the context of awarding compensation by doing that which the legislature said they should do. Should act in good faith, reasonable prudence. How does the recipient of the compensation protect his interest? By doing what the statute says. The statute says the recipient is entitled in good faith to rely on the reports and actions of committees of the board, and that's what we're prepared to try.
There are claims, aren't there, that the corporation can bring that the Attorney General can't?
Yes?
I mean, the overpayment of the phone bill, presumably.
Yes? Sure. It's not a parents' patriot case, and I submit that's not what we're dealing with. If this
Okay.
were a case,
But if it is, I mean, if this is just, if Grasso is just in the position of someone who found $1 million on the sidewalk and it's somebody else's $1 million, then the stock exchange could sue him for the million.
Of course. They could bring a case for mutual mistake. But this is not a case about a mistake. This isn't about a typo, and it's not about a phone bill.
Well,
It's about
after the report that they had commissioned here, for lack of a better word, could
Yeah.
they have done anything? Could they have commenced any action?
Of course they could.
As
They-
opposed to giving the
Refer-
report
handing
to
it
the
off?
Attorney General?
They could have, what you see in counts 2 and counts 3, which are the claims under section 720A1 and 2, which are for the receipt of an unlawful transfer by a recipient who knows of the illegality, they could have brought those claims. The stock exchange could have brought, or in the event, Your Honor.
They could have brought.
Yes.
1, 4, 5, and 6, too, couldn't they? I mean, you say there's and obviously there'd be no standing problem.
There'd be no standing problem, but there would be a
You say they're substantively bad.
They're substantively bad because they'd be seeking to impose liability without fault.
Do we have to reach the question whether they're substantively bad, or can we decide this case just on standing?
Of course you can decide it just on standing. Of course you could decide it on the grounds that he could not be a parents' patriot plaintiff at all, not on these facts, not where the entire case was worked up by the stock exchange and handed off to them for collection. Of course you could.
Well, that's true. That much is true of the second and third causes of action.
Except there the statute expressly
So
offers.
even though the stock exchange worked it up and handed it off, that doesn't taint.
Of
those
course,
rights.
because the legislature said he could. So I submit what is before you, although styled unjust enrichment claims, are statutory claims. They're just not authorized by the statute. If you see in the record, in the complaint, the very page 280 of the record, it starts against Grasso for constructive trust, but that's the end of the common law part. Then begins, Grasso is subject to the provisions of 515B, meaning the limitation on compensation. And that goes on in the next page to say, the payment to him of compensation was unlawful and ultra vires because it was excessive under 515, and to the extent he received unlawful ultra vires payments, a constructive trust should be imposed. Now, that's all about the statute. But the legislature thought about what happens when someone is overpaid under 515. And it said, who is liable? Officers and directors. What's the standard of liability? Good faith and reasonable prudence. And who's the trier of fact? The jury.
More is needed for the sixth cause of action, which seems to be, in fact, Section 720B mentions an action by the Attorney General. Why is parens patriae needed for the sixth cause of action?
Because the Attorney General would like to proceed on a no-fault basis. The sixth cause, in other words, they can sue Mr. Grasso for the alleged receipt of an unlawful loan as long as they meet the standard of the statute that the legislature insisted upon, which is proof of bad faith or imprudence. They can, either the loans or the excessive compensation, whatever elements they want to complain about, they just need to meet the standard that the legislature set. But what the Attorney General wants is a no-fault.
Yeah, I mean, if you assume he got a loan that's unlawful under the statute, isn't there a good argument that he's charged with knowing what the statute says?
Well, it would depend upon the facts, and here, of course, the issue is, was it a loan at all? So, in other words, this is an advantage.
You're saying that can be litigated under the second and third?
Absolutely. All of the mud in the first 20 pages of the complaint, if it were real, if they thought they could prove it, would support a recovery under the second or third cause of action. But apparently the Attorney General is not particularly sanguine about it.
Well, they can prove he got quite a lot of money.
They can prove he got a lot of money, but the legislature said that's not enough. It's not how much he got. It's whether, under all the circumstances, he acted in good faith and with reasonable prudence. That was the choice the legislature made, and the Attorney General can't make it, poof, go away by saying it's all unjust enrichment. In fact, in the Sperry case, this court dealt last year with a litigant who was trying to get around the limitations of the Donnelly Act and of the CPLR by taking an antitrust case and then, after the antitrust causes of action, try to plead it as an unjust enrichment case. And this court said, not so fast, that you can't escape a statutory directive, a statutory prohibition, by couching it in terms of unjust enrichment. And the fact is, there's a reason that the Attorney General has invoked the statute where he has. The reason he's done it is that the common law would never have given him a no-fault platform for recovery. The common law itself embodied the business judgment rule. Let me spend a minute on 719F, which General Underwood mentioned in her argument. Section 719F is not an invocation that all other standards of liability can now be imposed on officers and directors, notwithstanding everything we just wrote in Section 717. All that 719F says is that this section shall not affect the liability of officers and directors otherwise imposed by law. This section, not the article, not the chapter, not the statute, the section. And Section 719 is a particular section. It's labeled liabilities of directors in certain cases. It is a self-styled, limited set of cases in which a director can be liable, to wit, by voting. And all 719F is confirming is that a director can be liable for breach of his duty for more than just a bad vote. He can be liable for misappropriation. He could be liable for any number of other things. All 719F says is this section is not the exclusive source of liability. Finally, I'd like to spend a minute talking about the parents' patriae authority and where it would get the Attorney General, even if this were a good parents' patriae case, which it isn't. The Attorney General writes that on page 16 of the reply that the Attorney General has eliminated one statutory element, which is the standard of liability, but has incorporated others and added others. But we're not at a rewrite, a markup session of a legislative committee. It is not an executive branch function to rewrite statutes, to swap in elements in favor of other elements, not where the Attorney General is, as here, relying upon the not-for-profit statute as the engine of each of the claims, as the reason the enrichment was unjust, as the reason it's ultra vires. Where you're relying upon the statute for the substance of your claims, you can't toss off the standard of liability that the legislature insisted upon.
Is there anything in the legislative history that supports that position, that the legislature intended to occupy this territory exclusively?
I don't think that the legislative history is telling on the subject of whether the statute is meant to be exclusionary, but I don't think the court needs to reach that issue, because the Attorney General is not seeking to invoke other liabilities created at common law. if you read these so-called common law claims, every one of them depends on the statute, depends upon the prohibitions of the statute under Section 515 for unreasonable compensation, depends upon the prohibition in 716 for loans. So what we're dealing with, we're not dealing with, sometimes this court has these incredibly difficult preemption
So
cases.
there may still be some common
Of
law
course,
authority left,
of course,
but,
they just haven't pled any.
but your posture is not in this case, but there may still exist.
The appellate division never needed to speak to what lies at the perimeter of the NPCL, what authority has been displaced, because these causes of action are drawn from the heart of the statute. They are drawn from the prohibition of 515 for excess compensation. They're drawn from the prohibition against loans. And then the Attorney General simply said, but I'm going to impose liability without fault, notwithstanding that the statute says, no. You couldn't have a more direct violation of the separation of powers because the Attorney General is relying for the substance of his claims upon the statute, but trying to jettison the entire liability scheme, trying to disregard the legislature's choices on who should be liable for what and who is the trier of fact. One last comment. I see my white light is on, and that is this. It's interesting to note what the Attorney General doesn't say. The Attorney General doesn't suggest that a private litigant, that the New York Stock Exchange could have brought these 4 claims. Why? You can see that the Attorney General's only defense to the separation of powers issue is the parents patriae alleged right to remake these statutes by bringing in new elements. But if a private litigant couldn't bring these claims, if a private litigant couldn't refashion the statute and enlist the judiciary, it could only be because the separation of powers forbids it. And the same constitutional doctrine has to apply to the Attorney General as to every other branch. So we ask the Court to vindicate the principle that a balance of co-equal branches requires that the executive also be subject to the separation of powers limitation and to affirm the judgment
Thank you.
below.
Thank you.
Judge.
Ms. Underwood?
2 points. We are not relying on the statute for the first 2 common law claims. We mention the statute because the statute codified a pre-existing obligation against excessive compensation. That claim for unjust enrichment for unconscionably large compensation exists in the world of for-profit corporations too. In the Rogers case cited on page 30 of our main brief.
But isn't a common law cause of action after it's codified become a statutory cause of action?
It might or it might not. The statutory cause of action, the statutory obligation codified the common law obligation. The question whether there can still be a common law cause of action, Mr. Zweifax says we are rewriting, swapping in provisions. More to the point, a common law cause of action has simply different elements from the statutory cause of action.
So
I just wanted...
your theory is that the legislature codified the common law cause of action, but not all of it, and left the old common law cause of action in existence alongside the new statutory one?
Didn't codify the cause of action. It codified the obligation not to pay excessive compensation, and a cause of action for unreasonable compensation, for unjust enrichment is limited and different from, in the ways that I outlined, the statutory action.
Isn't it difficult then for any not-for-profit, I realize this is a rather high-visibility one, but any, as you mentioned, country clubs or veterans posts or anyone else who may be subject to this, to know where their rights and liabilities and limitations lie, if under your argument, not only do you have the NPCL to worry about, but everything else that the common law may or may not have given or taken away?
I don't think so. For one thing, the prohibition on excessive compensation is the same. They know the standard of performance is the same.
Well, there's an issue of
The
fault
question
that your opponent kept talking about.
Well, the interesting thing about the Rogers case, if I could just for a minute, is that was a case like ours in an interesting way. The Supreme Court held that a company adopted a formula for compensating corporate officers with a percentage of profits, that was reasonable when adopted, so there was no fault in adopting that provision. But the changes in the market made that percentage of profits so high. The numbers don't seem so big today, but they were big in 1930. made that percentage of profits so high that the compensation became unreasonable, and a shareholder's claim for unjust enrichment would lie. That is to say that even where there is that was not a not-for-profit, and that was not the Attorney General's parents' patriarch power, but that's to say that a common law cause of action for unjust enrichment can exist alongside, for unjust enrichment without fault.
How do we know that the legislature intended to abrogate the business judgment rule?
I don't think it intended to abrogate the business judgment rule for the purpose of liability, for damages. We are talking about the limited ability to take back from the holder of excess compensation. This is not liability on the part of the directors who enacted it. This is not liability for damages that flow from it. It's just an obligation to give back what was improperly taken without fault.
Is it your position that Mr. Grasso is liable even if he is completely free from fault?
That's correct. That is correct, as long as there is some predicate for a finding that the enrichment was unjust, just as if he found it on the sidewalk, or it was given to him by typographical error, or voted to him by mistake. If it turns out that he had no business having that excess compensation, he's liable to give it back, not for any damages that flow from it. That's the difference between that and the business judgment rule.
Even if the board exercised business judgment when they granted it, for the sake of argument?
Yes. They are not liable. They are protected by the business
But he
judgment
has to,
rule.
even though they exercised it in carrying out their business judgment, and he received it, he now has to give it back, even though he was not at fault.
That's correct. If they exercise their
theory.
business judgment, and for instance, they were, however, misled through no fault of their own into authorizing something that they never would have authorized, maybe someone else is at fault. I mean, there are a myriad of situations.
Or, I mean, of course, presumably, a guy who finds $1 million on the sidewalk and refuses to give it back is at fault in some way. I mean, you're supposed to give back other people's money. But even if you imagine that he had no way of imagining that he was at fault, he's still liable?
That is unjust enrichment. That's the second wife in Simons, who was not at fault in any way, but the deceased husband had left all his insurance to her, and the first wife, who had an expectation of getting insurance, was entitled to take it from her, even though she had absolutely no fault as far as the case shows, because it was thought to be inequitable to deprive the first wife of that expectation. The other thing, if I could have just say one more thing, is that the last two counts, the statutory counts, it is not at all clear that there's a good faith defense even under the statute. That is to say, the prohibition on loans in 716, 716 says authorizing or participating in a loan. Participating
Well,
means...
there's no good faith defense under the two claims you already have. That's a reason to let you litigate those claims and not give you the other four, isn't it?
That would be a possibility, but what I'm saying is that whether there's a good faith defense or not, we take those two claims as the statute constitutes them, and we say we have the parents' patriarch power to
Thank
exercise.
you.